We have two kind of laws: the common law, the civil law. First, the common law. It comes from the Anglo-Saxon system that it was made in the 11th century before the Norman conquest in England. And its main points are that it's derived by the custom and judicial present rather than statutes. The countries that use this kind of system are UK, USA, Australia, and a lot of countries that were conquered by the UK. Also, in the courtroom, we have the judge and the lawyers. In this hand, the judge, he plays a role of a referee, and the lawyer, he has to, or she has to convince the courtroom that they're right. Meanwhile, the civil law it comes from the Roman law, and it comes from the 529, the 29 of the Justinian Code that was made in those years, and it's a kind of law that it's based on the Constitution, and it takes place in places like Europe and a lot of countries that were conquered by European countries like Mexico, Brazil, Argentina, etc. Also, in the courtroom, in the civil law, the judge, he plays a role that he has to determine whether if it's wrong or right based on the Constitution and the laws. Meanwhile, the lawyer has to create arguments based on the Constitution. We can say that the common law has a unified courtroom structure, and the civil law this diffuse court structure.